to address the concern that a VSAC grant or something like that isn't really applicable here. There is, I will just say, I think there is potentially some value to the secretary to have a list of other investments that the state might have made in the farm in the past, because
I was going to speak to that because I
Okay,
think
good.
that's really.
Well, why don't we have you speak to that? I know you were in yesterday, but we've got different language now. So if you want to take it up again, Representative Janning, thank you. We're all set.
We're ready?
Yeah.
Edie Branning, Jericho. Here with the amendment on S60 and yes, agreeing that state grants or loans for the purpose of the farming business makes perfect sense to limit that there. One of the reasons that having that list is important is if the state is nurturing a business or has a business in a certain, that's really important information when you're deciding to grant more money, because once we've decided as a state that this is an important business, we're valuing it, we want it to happen in an area, and then we realize that it's in a hardship situation. If I were in the position of making the determination, I would say, yes, we need to help this business where we've already decided, right? Someone, has already decided. So that's another reason that that it made sense to have a list of, the money. But if it is not for the farming business, then I don't know that that's relevant.
All right, good. Questions for Representative Branning? Nelson?
Yeah, that's better. It's a little bit burdensome when you've been getting grants like for no-till cedar or buffer strips or like dairy farms. Every year we get FAP money to put down cover crop and whatnot to increase our practices and retain our soils. So these are all things for a dairy farmer. I can speak to that. I can't speak to the veggie farmers as much, but they'll speak to that. But I understand also the avenue you're coming in at, and this is a valued business, and so.
Right, you're doing all the right things.
Mhm.
We want to support you when you need the help.
Right. Representative Ryan.
I'm just a scenario here. Farmer has $50,000 in losses, applies to this Vita loan for say 25,000.
Not this loan, the Vita loan.
Right. Your amendment, right? Yeah. And then also, right, the farm security, and then potentially not getting any farm security money because it's all gone, because 44 million was lost in flooding in Vermont, like in 2003. Would it even be possible for them to apply for another Vita loan outside of that emergency 2 million?
I don't know all of the Vita programming, so I don't know that I could answer that accurately. I would think it's possible, but I don't know that. I think you'd probably want to have Cassie or somebody else from Vita in here to talk about
Representative Burke.
I guess the only thing I'm a little fearful of is the potential. And it's interesting hearing your perspective of wanting to make sure we support a farm that has received grant money to I was seeing on the other end of potentially where, it could be used against a farm who has received grant money, where the committee could say, or the board say that, you're only receiving money from the state, and we need to figure out who, there's another farm that hasn't been, applied for a grant and didn't receive it and now has this disaster. We're going to help them instead. So I'm a little leery of the potential, what this information could do or how it could be morphed over time if the board doesn't see the intent that you have behind it, because I feel like you'd be twisting the opposite direction where if a business has received grant funds, then we're not going to fund you because you're already getting money from the state.
Well, and there is the question as to should we be providing funds to a business every year for losses if they're farming in a place that is no longer habitable for farming. So that I would see as a way that you would want that information as well,
I
right?
definitely agree with that.
So,
But that would just narrow the scope of collecting the information based on, grants for the sake of disaster relief, instead of a grant for a cedar, where that cedar really has nothing to do with Richard's business practices necessarily. Any disasters. So I'm thinking of maybe the instance of a business like Pete's Greens receives a grant for facility updates. And then has the very next year a flooding event that wipes out a bunch of their crops. And they go to apply for, money for that and are denied money for that because they just received money for their business the year before. Totally unrelated to this disaster, but I see the potential of that occurring. So there is the other option of maybe limiting the language to grants received for disaster relief. So if Pete's Greens received, $50,000 the year before for the same exact field that also got flooded, totally understand that. But if they received $50,000 simply to add on, storage capacity, I wouldn't want that necessarily to be a rubric for saying, okay, we're not going to give you funds because you're already receiving in the same. It's a thriving business, it's a growing business, and then to penalize that business because they've received a grant for something else. I think it might be an issue.
I think probably the reality is whether or not somebody lists that information on the application, people are going to know that. As the secretary has that information available somewhere, probably fairly accessibly. It's who's gotten those grants in the past. So I hear your point too, and we can't be in the head of whoever's making that decision, down the road at some point. But I think that I still feel comforted by the fact that the farmers themselves are okay with this, with the idea of having it be not just disaster money, but other money instead that would provide, that insight to what investment the state has made in the past. So, John.
Just to Representative Granning's second point, there's no element in our language at the moment where there's sort of a post-mortem conference with the farmer saying, maybe you shouldn't farm in the floodplain right here anymore, mitigation type things. I mean, there's nothing like that, is there? Just so it doesn't become a chronic type thing, or just think about your options. It doesn't even have to be, necessarily just, prescriptive, but without, punishment.
I don't think there's anything in the bill that spells that out,
Just common sense.
Yeah. And just process wise here too. So this is, this is the first time we've been in this sort of at this stage in a bill and are looking at an amendment to it that somebody else had brought. There's nothing in general to prevent the committee also from looking at something after it's been introduced. Oh, we missed something. We want to add this in. That can be done too. So I think maybe why don't we let Representative Granning go again? Thank you. I think we've heard all we need to hear there.
Thank you for having.
And I'm going to actually, before you go, so that we're all clear, we're going to ask Ledge Council to add 2 or 3 words to that line to limit it to farm business, essentially.
Purposes of the farm business.
Okay. And then we'll let you do that, Mike. We'll look at it again, and then before we leave at the end of the day, come to a decision in the committee. Good. Thank you.
Thank you.
All right. Thank you, Mike.
Sure.
Okay, now back to our regularly scheduled programming. Laura, do you want? Yes, correct.
Sorry, one thing.
Yeah.
I want to make sure. I mentioned to Michael Brady, but to make sure forestry is a word. It's only saying farm. Just to make sure.
Oh, yeah. Yes, farm or forest business.
Should I?
We'll catch them. Yeah. So, but thank you. That's an excellent. Yeah. So, Laura, welcome
Morning.
today. So we are having you in this morning to give us in 45 minutes or less everything we always wanted to know about the RAPs. And this could be a discussion that we might have anytime, actually, I guess, during the year. But because we've got in S45 the right to farm bills specifically referring to the RAPs, it seemed like, and we talk about them all the time, and we have a vague understanding, and we have heard in the past, the committee has. But thought it would be maybe good just to spend a few minutes hearing from the agency. So that's why you're here.
Great. Well, good morning. I'm Laura DePietro, and I'm the Director of Water Quality at the Agency of Agriculture. And predominantly what my job is to impose these rules. If you recall, I gave you all your own special copy at the beginning of the year, so I didn't bring any more for you. But yeah, as far as these rules and how they interplay with neighbors, I'll say, or adjoining landowner and activities, the first part is a reminder that most states do not have these, right? They do not have non-point source rules. That's what these are, is to deal with non-point source pollution. But in addition, because engaging in these rules and following these rules does provide some exemptions from municipal oversight, these rules also have some of that in them, right? So essentially, in some ways, the state agency of agriculture plays a role of like statewide zoning, right? So if you're a farm that's in multiple towns, it helps to be on the same landscape in terms of understanding the requirements in each town. So these rules are sort of the underlying piece that puts that all together. However, with that said, the first goal is to follow whatever a municipality has set up, right? So if a municipality has a setback that they want for a structure, the first goal is that, well, farms in this, it does require farms to go to the municipality to say, I'm going to build this structure. And the way that it's set up is that the person doesn't need to get a permit from the town, but say they are building something now and they sell their property and, 20 years later, that thing becomes something else. It becomes an apartment, right? Somebody retrofits it. We make sure that the people went to the town has the dimensions, they know where it's located, and the goal is to make it a conforming use, if that's familiar terms for you all. Because if it's non-conforming to what the municipality has set up as regulations, it could be a challenge down the road for a future landowner who's trying to turn it into an apartment or whatever they're doing. So that is why we do that. But sometimes, if you can think of our landscape and think about some of the farms that exist out there, there are definitely 100, 200-year-old barns that are not conforming. Because of how the landscape has built around it with roads or whatever. So in the RAPs, there are setbacks to roads, there are setbacks to property boundaries, water supplies, both public and private, houses. So there's all kinds of setbacks that we establish. But sometimes, like a simple classic example is if you have a barn, it typically would have, if you have dairy animals in there or anyone who generates manure, there's going to be a gutter system or something that gets the manure out one end of the barn. That end of the barn may be close to a property boundary or a road or something to that effect, but that's where you've got to capture the manure. It may be a smaller storage that gets it to another storage, right? But it may be within 50 feet of a property boundary as an example. And so that is where we have the ability to say, well, the town would say no. And we can say there's no other option really that exists in that situation. And so the process is that the neighbor is notified. There's a public process through the town that it's posted. And we listen to comments and understand what the challenges are, and then try, if it makes sense, to approve a variance, is what we call it. We take all that into consideration when we make that decision of to approve or to disapprove or to modify the project or whatever we need to do. So that's typically, and the landowner, the farmer typically, there's a whole list in the back of the RAPs of like, there's a whole appendix A that explains to them for asking for a variance, what they have to do, and what they're responsible to say why they need that variance, right? They can't just say, well, because I want it.
Who are they asking for a variance from? Or who is going to award them a variance?
Again, if you think about it, I mean, we're not technically like the zoning agency, but in some ways, again, the goal is, can you meet the municipal setback? That's our first focus as Agency of Ag is looking at it, but the Agency of Agriculture can issue a variance to a municipal setback, essentially.
Representative Brown.
Or do you know, even anecdotally, have there been cases with, I can see with Act 250 or municipal zoning where somebody's tried to develop something and then they realize it's not going to fly, or it's just going to be a long battle with the land use review board, and then said, I'm going to make this farming.
And so what's your question?
So that would make them exempt, right, from municipal and Act 250 if the change was going to be agricultural.
So many, it depends in that statement.
All right.
It really depends on the activity, right? You have to be farming and principally producing something. So to start there, right? And if you're familiar with accessory on-farm business, when you start to get into some mixed uses of that, there is still the requirement to meet other municipal requirements that may exist, such as like parking and lighting and other safety type things. So certainly, people, they could try that. But underlyingly, what would happen is, say they did that, but then they were like, oh, that was just a cover to get it what I want. As soon as they go back to doing, so if we said, say for whatever reason, we could issue a variance, it made sense in the case because they made a good statement that they were arguing, their farm. And we check all those facts, right? We ask all those questions. And so we give them a variance in this hypothetical example. Every one of our variances says at the bottom of it, if the circumstances change, this may not stay. So it's not a forever. It's based on the fact that you're farming and you have to stay farming. And so if they don't and they go back, then the municipality has all the ability to say that is a structure or activities that they regulate and they can enforce in that space if they wanted to. So we really work with people when they come in and try and explain to them, it is in your best interest to be compliant with all the things, because then you have flexibility forever for that thing that you built.
But you need to be farming, let's say there was an indoor tennis court in a town and you were like, I'm a new farmer, I want to make this into a chicken farm. Is there a problem then because I wasn't farming? I'm a new farmer and I want to get into agriculture.
Yeah, the way the RAPs are built is you can, because obviously if you want to start farming, you want to be able to do that, but be in compliance. And so you can write a business plan. We have a whole process of what needs to be included in a business plan to submit to the agency to show us that you're meeting the requirements based on your business plan to do that. And so we put them through that process. So it may be, again, maybe they bought something that was an old barn and they needed to add on, or they want to put like a farm stand. That's a common one that we get is the farm stand, because it makes part of their business model sense. And it's the only place they can do it because of how the property is structured. In that case, say we did approve it. They need to make sure they keep farming, because if they stop farming, then that's no longer a protected structure under the ag exemption, essentially.
So the business plan then counts it.
It can get you started, yep. But, and we've gone through, some business plans. We push people in places to say, like, we really need to understand that you're going to achieve these goals. So, and again, we try and be clear with people. It doesn't make sense to not have the right intent, right? Because it's gonna cost you more money and it's gonna hurt. You're gonna probably potentially have to take the structure down. So do it right the first time, so that way you don't misstep and waste time, money, all those things.
So two questions, but the first one, the more foundational one is, do you remember when the RAPs were created and who was part of that process of creation?
I was not involved when it was created, but back in 1985, that is when the first set of RAPs were created. And when you read the preamble of those, essentially what seemed like what was happening in the legislature, there were all these conversations about farming, and I'm going to call them exemptions because it's an easy word, but lots of allowances for farming, essentially. And nobody had defined what agricultural activities were. And so everything in the statutes was starting to say something about agricultural activities. And so the legislature directed the Agency of Agriculture to define what are accepted agricultural practices. And so that's when that first set got created. And it's a pretty small set of regulations, but it included winter manure, it included nutrient management stuff, it included some of this farm structure and setback things. So it was meant to address those things that were coming up.
And then to follow up with that, since the 80s, farming has obviously changed so much, from industry in Vermont, from practices, from climate change, from technology, all of it. So how often are the RAPs looked at and amended based on those current reflections of how the industry is shifting, or are they?
Sure. So 85, so it's 85, 86 was the first set, 2006 was the next, 2016, 2018. And that's where we're at. We're at 2018.
And the process of changing the RAPs, who's involved in that?
Generally, each one's probably been a little bit different. But generally the ones that I've been involved with, obviously we work within the agency to craft it. We are responsible to work with DEC to make sure that those are aligned. ICAR, we go through every organization that's in government. But we generally try and do a really big stakeholder outreach. So like this last set in 2016 and 2019, the Agency of Ag, we did over 90 meetings that were bigger public meetings, and then also met, with Rural Vermont, NOFA, at that time, the Champlain Valley was starting and Farmers Watershed Alliance was starting. So like all those organizations independently, and then the bigger public meetings. So really our focus, at least at the Agency of Ag, has always been, if you're going to create a set of rules, they have to be something that somebody can implement. And so we really try to get stakeholder input, but obviously, public input as well. There's lots of comments that we always get with these rules every time we open them.
Great, thank you. It's really helpful context.
And just to follow up with that, or are in the cases where there have been revisions, 2019 or 2016 earlier, were they directed by the legislature, or can they be changed at any time?
They can be changed at any time.
The agency has that authority.
Yeah.
Is it the ag agency or A&R, or how?
It's the ag agency. It's the rules of the ag agency that we manage. And so if there's a need to revise them, certainly we would revise them. And yeah, some of them, I think, at least looking historically of what changes have happened, the agency used to be a department, became an agency. FS or NRCS used to be called something else. So like all the terms at one point were pretty behind. So that was one impetus for updating. But, Clean Water Act of Vermont was another one. Tile drainage, when that was legislatively directed, was another one. So it's sort of a combination of needs on either end.
Just to follow up on your line of questioning, what's the relationship between RAPs and accessory on-farm businesses?
Well, so the RAP, so they're separate in many ways, right? But so the accessory on-farm business, municipalities are the deciders in that, they're the driver. But they would look to us often to say, is this really farming? Do they meet the standards? And so one of the processes, because this defines who's farming, right? And so we have a process that we created in the last couple of years because we kept getting calls essentially of like, is this person farming? And so we have what we call a farm determination that people can do. And so we gather information from the operation to make sure they're meeting the threshold criteria. So that's sort of how they connect most often.
Okay.
And the variances also be granted by the agency to a municipality to let that.
They could certainly, if for any of the structures, but again, we're usually talking directly with the municipality. So we have a staff person on board who pretty much their main job is to talk to municipalities and make sure that whatever activities are ongoing, the municipality is okay with. We hear their comments, obviously, and there's a lot of education that goes back and forth because, as you all know, you're learning about this topic. It's not always easy to understand until you get steeped in it. So with new turnover in towns, we spend a lot of time educating, and we do a lot of work with Municipal Day and VLCT. So we try to just focus on making sure that everyone's aware of what they need to do in these spaces.
Cut you off at some point, or we broke in the
Yeah.
middle of your narrative, so.
Yeah, I don't know exactly what kinds of questions you might have. So there we go.
Let's find out.
Can you talk to us a little bit about water? And, I fully understand that water will be clean when it leaves the farm, but talk about water in S-45, there's been a lot of concern over trespass with water.
Mhm. Okay.
And so, and there's rules about water in the RAPs, I'm pretty sure.
Yeah, well, so functionally, water it moves everywhere, right? To anybody's property, water is constantly moving towards whatever downstream thing it needs to get to. But the focus of these rules is management practices need to be implemented on the farm to ensure that, for instance, your soil, your nutrients stay on your farm. And so, as an example, if you have a situation where a property is next door to you and you are not doing your soil practices, right? Your soil health practices, and you have erosion and you have a plume of sediment that goes on to the neighbor's property, right? We would say you're not in compliance. You need to follow your soil health practices and make sure that you're sustaining yourself such that you shouldn't be losing your soil in that way. So that the whole thing here, and a lot of that bases on, we call it nutrient management planning. And there's a lot of math that goes into it and science over the years that USDA has developed to say that these practices should be sufficient to keep, because the whole focus really is, if you're going to lose your soil or your nutrients, you're not going to be a very productive farmer. So to keep everything on the farm. And so we do, again, we have this, things can't cross property boundaries, but of course water crosses property boundaries, right? That is natural on everyone's property. But we make sure that you're following practices that ensure that that water should not be taking, significant nutrients and sediment. However, with that said, agriculture and all activities, non-point source, there is some constant pollution on all things that are happening. We can't control every single little bit, but the focuses of this is to make sure that it is well managed so that it doesn't happen at a level that would become a concern.
Non-point source. It's not a term that we use out in the real world. And we did hear the testimony the last couple of days about CAFOs and how they are a point source. So non-point source in the agricultural context is a field.
Yeah, that's a good example. And when it rains, water runs downhill. And so it will go through that field into either surface or through groundwater downstream. And so, inherently, non-point source is meant, it's not something that you see coming through a pipe or through, a ditch. It is runoff, essentially.
So I'm just reminded, though, as we're and I wasn't intending to go here, but I think we heard the other day that, and this is, I think, important to S45, that tile drainage is considered non-point source, even though there are pipes involved.
It depends, right? If you manage it, and so if I jump to federal context, in the CAFO rule, the description is that, essentially you follow a nutrient management plan. And if you're following that nutrient management plan, again, and we've adopted higher standard of a nutrient management plan in the RAPs, that if you're following that anything that would leave that tile would be considered exempt. It would be a ag stormwater exemption. However, if you don't follow that plan, right, and you way over apply manure, say, and the manure is coming out the tile, you are not exempt, and that would be a point source violation. So it's about making sure that you implement the practices and maintain the records to show that you've implemented those practices.
Representative O'Brien?
That was where I was going to
Okay.
file. Like,
All right, well, what other questions do people have? So again, the language in S45, and I know that you're not, maybe you did take a look at it, but I mean, what in the various drafts, there are references to following the RAPs. So what else should we be thinking about and, understanding what that might mean to different kinds of farms?
Yeah, so I mean, the kind of activities, if you think about what are in the RAPs, another space, obviously it's like the personal boundary is one space where people might have struggles where, again, we say if you have a mortality, it has to be so far away. Like, so for instance, I think it's 300 feet from a house. If you have just a stack of something, right? Like if you got a bunch of goats and you've got a stack of goat manure that you clean out your barn, that has to be so far away from your property boundary. It also, and yes, and your neighbor's wells, right? So you do have to pay attention to where wells are, especially community wells. Community wells has a bigger setback. But there is also this space where there's the balance where the neighbor is responsible to make sure they put their well in correctly, right? If they put in their well illegally and too close to your property or didn't get it verified or whatever, then the rules don't apply in that same way because they didn't comply. So it's a little bit different in that space, but it's intended to say, and we can sample in these rules, we have the power and authority to sample the neighbor's well. And if we find that there is concern that there's agricultural pollution getting into the well, then we can tell the farmer, you need to do X, Y, and Z. The other thing that these rules do have in place is that even if you're following the rules, because they're statewide, right? They're for all farming types. It's hard to write a one size fits all. And so within them, it also has, if they're following the rules, but you can still see that there's a problem, right? For this situation, it didn't work, then we can say they need to do more, right? So we can go above and beyond these rules. So we have that power and authority in there when there's a water quality issue that would arise. So where you stack stuff, where you build stuff, how you manage the land, when you can do certain activities like winter spreading as an example, are all in here. How your animals can graze, you making sure that they're protective of the stream banks. If you wanted to do stream bank, so a couple things. So farms are not like exempt from all types of other regulations, right? And so, if you wanted to do rock line the stream because it's eroding, you still need to go through a process to make sure that it meets standards so that way it doesn't deflect and cause the same problem to your neighbor. If you want to construct something that's larger than an acre, you still have to get a construction stormwater permit. So there's these activities, if flood river corridor and flood hazard stuff, farms still need to follow that. So a lot of that is built into these rules so that farmers are aware of it as just a duplicative effort. But also, we could enforce and say, you didn't do that, you needed to do that. Often what we'll do is just talk to A&R and let them enforce because it's their rules, but at least we can notify that there is a concern. So there's a lot in here that just makes sure that how you manage what you're doing is appropriate and consistent. And so that's just the RAPs. There's also the large farm rule has additional protections that we can put into permits. So for like odor, flies, noises, traffic, and the way that we manage those nuisance activities is essentially, what does a normal dairy look like? And does yours fit that, as an example? And so if you're outside of that, what seems normal, we can step in and say, you need to do X, Y, or Z. So yeah.
So, I'm just thinking aloud here. There are, I think we see every year in the report on the MOU, a count of how many investigations there were, maybe complaints. I don't know whether they're typically complaint driven. But what could you just say anything about what are typically where do farmers have challenges complying with the RAPs? Are there particular practices that might be difficult to comply with?
Let me answer it differently, because I think the type of interactions that like most commonly come up, or the challenges that we as the sort of middle party, right, the enforcer of making sure that this is all in balance, come across is, I sort of see two things. I think one of the common activities that we see that neighbors might call us to complain about are often manure related, often maybe a pile, a mortality is a common one.
Can you
And
explain what that means? Like a cow dies and what do you do with the body? Is that what?
yeah, and I mean, honestly, like, you know, a lot of the things that we do talk about with complainants, they often tend to be smaller farms just because of the parcels get smaller. The larger farms tend to have space to manage. But yeah, so when you have an animal that goes down, you have to deal with it. And there aren't that many services that come by and pick up an animal and take it away. And so you can bury it, you can compost it, and it's all in here about how, and it tells you, you know, how far you need to be off of bedrock, or you can't be on bedrock on something, you know, and like how far from properties, how deep you've got to bury it, all these things. And so those are common things that we'll get is, you know, often around a well, right? Like concerned about my drinking water, my neighbor's doing X, what can you advise? And so we get that, we go out and we investigate the situation. You know, we take all the measurements, we see the compliance. And, you know, a lot of times if they're not compliant, it's often a very easy fix. And it's an educational moment of like, did you know this rule existed? And because again, sometimes these are very smaller operations that don't know about these rules, like some of the more regular ones in our suite that we work with. And so move the pile, that's the answer, right? And they can do that. So those are the most common ones. I would say one of the things that I see as an interesting challenge on the flip side is a lot of times the complaints that we get have nothing to do with the farming activity. There's two personalities who do not get along. And that's really underlyingly what's driving the complaint, is just two neighbors who don't like each other. So in that case, which again, those are sort of the ones that come up, you know, fairly often, because it doesn't matter what the farm does, the person's calling. And so, you know, we investigate them and navigate that. But when we realize, you know, the two parties really are struggling, and it really is a communication issue and an understanding between the two of them, we work with the Environmental Mediation Center. And so help bring them into the fold to try and get people to communicate better. I know myself, I've gone out in the field many times and tried to do that, right? Just that's really all it needs to happen is, you know, and that's always one of my first questions when I hear a complainant and I hear, you know, you start to get the questioning and you realize this doesn't sound like it's actually about this, but we'll check that out, you know? And, you know, this like the first question is, have you talked to your neighbor, right? And sometimes you'll say, well, they won't listen. So that it's a lot of work in that space to just get people to communicate, because that seems to be, once people understand why they need to do X, Y, or Z, or what they could do to do it differently to appease the other party, you can make progress on a lot of these.
If, what is it, 124 goes forward, is there anything in the RAPs that have to be adapted to recognize CAFO permitting as opposed to LFO and MFO permitting?
No, I think everything is structurally in place, because LFO is there still and RAPs apply to everyone no matter what, right? Because it's the non-point source set of rules, so they won't go away.
Biodigesters under the RAPs?
The production of energy is something that is under that. And so the role the agency will play, for instance, is like if a project is coming through the 248 process, which is to get a certificate of public good, if the agency has concerns about the project, can sort of step in and say, we'd like to have a say in how this project is developed and put our comments forth and work with the applicant to come up with a memorandum of understanding of things that we might need them to do to make that project fit the goals better.
Right. Any other questions?
My one other one was on wetlands. Do RIPs get into wetlands at all? I know it was sort of interesting with waters of the state versus waters of the United States. That showed the water go to of the agency.
Yeah, so farms still have to abide by wetlands. And admittedly, it's more confusing for farmers because not only do farmers have to abide by state DEC wetlands, but they also have to abide by USDA wetlands, which is a different definition. And so essentially, and we've had, many attempts to try and make it easier, but it's state regulations and federal regulations. And Army Corps is also in that mix as well. They manage waters of the state. And so for farms, they have triple layer oversight on wetlands. So it gets a little more confusing for them in that space, but it's the thing that is exempt, that is clearly exempt for farmers is just if you're farming land and it's been farmed, you can continue to farm it. What the trip up is if farmers start to get into lands that were not historically farmed, and try and operate them as farmland, they could affect wetlands and the drainages, and that's where they would trip those other rules. But the RAPs do not regulate wetlands because there are already 3 layers of wetlands. However, with that said, though, wetlands can be waters of the state, right? And so under that guise, yes, the RAPs do. So like we've had instances, right? Like a pile of horse manure is piled in a wetland, right? Because at that moment, the cattails start and the standing water is there and the pile is there. That is a violation, right? Because that is manure in water. It's the kind of thing where we would let A&R decide if they want to take jurisdiction first, but if they don't, because maybe the wetland doesn't connect to anything, we can, or maybe it's not a significant enough wetland, whatever the reason might be, we could step in with the RAP. So for us, we do look at where waste might go. And if it goes to the waters of the state, which can be inclusive, we could hold them accountable.
Is there a unified definition of wetlands that all 3 of those different jurisdictions?
There is, yes, there is. The Army Corps has the definition of a wetland, which is essentially, making sure that your soil is hydric, that the plants that would grow there would be hydric. And so generally they use that same definition across the board. However, the question becomes, like state is what's navigable versus not navigable. So federal is clearly navigable water and things connected to navigable waters, to where a very isolated thing that's not connected to another water body, like by, you couldn't get in a little canoe and go to it. It could be a state jurisdiction, not federal jurisdiction. So it depends. But yes, there's a similar definition, but it's all based on going out in the field, looking at the details. And, there's a chance that 2 different people could make a different determination, because it's all representative using your science and applying it in the field. But generally, they're pretty consistent.
Right. Anything else, Laura, that you would want us to know before you leave?
I guess I would just say, just my experience, and I was glad to see some of the change in looking at, because farms do change, right? Either they become different operations, it's been fascinating to me over these years to watch. It's like we want to diversify farms, right? Like this whole concept of how we try to make sure that farming stays viable in the state conflicts with the idea if you can't change, right? And if you become liable for, or you become susceptible to nuisance or other suits. And so I do see that as an important piece of what the landscape fabric that, all of the state seems to be pushing for farms, that is very helpful in S45, because I've definitely seen, a dairy become a goat operation, or a farmer implement new technology. And so there's these changes that I think, are important, and we want them. They're better often, is what I see. So just making sure that those are included, I think, has been a good thing.
All right, thank you.
Yeah, thank you.
And after lunch, we're going to pick up the conversation. Actually, not immediately after lunch. We're going to take some testimony on S124, sort of related. But then we're going to also hear from Heather Darby and Josh Faulkner specifically on tile grading, because some of us have better understanding than others of what that entails. So we'll be back at 1 o'clock.
Are we gonna have?
We're gonna take a break right now. Yes, we're all done today.